we talked. I have to click the thing. Okay, I clicked the thing. So we talked with Legislative Council, and they, of course, Sine Die was last Friday. So I'm sure Susan's life got much easier. And moving forward, we're going to give Legislative Council is going to need to process everything that happened this session, because there was quite a lot that happened. Sadly, not much on the tax side, but there you go. And so we're looking at probably May is when we need to have everything to Legislative Council, so they can take what we're putting together and transform it for substance and style purposes, to fit into the format that a bill would look like. So so I think we're sitting here at the beginning of March, sort of early to mid-March, and looking at not a whole lot of time to get through a lot of stuff. And so what I would propose is that we have one more meeting in March, have an early meeting in April, see where we are, and then potentially have a second meeting in April, just to make sure get through everything. I think we're going to be able to move pretty quickly through the articles, because I think we spent a lot of time discussing things, but we did come to a conclusion on a lot of these things. But I want to make sure that we've got enough time in the next 2 months to get this completed. So does that sound reasonable? Okay.
I assume that second March meeting would be after spring break.
Yeah, that's what I'm thinking. So spring break, I don't have kids. So for those of you who do, you're going to have to correct me if I'm wrong, but I understand spring break is the week of the 21st, right?
Correct.
So
That's correct.
The week of the 29th or 28th,
yeah.
rather. I could do the Thursday. What does the 31st look like for everybody?
I actually can't do that week. I've got Ninth Circuit argument and mediation all day and other meetings.
That's fine. I mean, you were good about putting in your comments on the first 4 articles. So, I think to the extent that you can continue to get or have your assistant put your comments in, I think that will accomplish what we need to accomplish. Does that week work for most everybody else?
So we plan on mornings, right? I have something that Thursday afternoon.
Yeah.
Oh, sorry.
Yeah, I do. Is it the tax book club?
Yeah. I'm leading one of the sessions.
I can actually do the first. That Friday.
I could do the first as well. Is there a preference as between the Thursday or the Friday? Well, okay, why don't we do the Friday then? So we'll plan on having a session Friday morning, same time, 9 to 12, if that works for generally folks.
It will not work for me, but that's okay. I mean, I can join at 11, but I'm not available.
Yeah, if you could get your comments in.
I think,
that would be
great. I think I already have actually.
Yeah, Roberta already.
Thank you, Cody.
So, and then as far as the first meeting, what if people think? I want to make sure that we've got, I don't think there's going to be a whole lot of things that have to happen between sessions, between meetings.
The one thing, just to make sure, what I'm committed to do, and Valerie and I have talked, is by the 23rd, I'll have the next set of my notes incorporated into that shared document for everyone to prepare for the meeting on the 1st.
Yeah, and I think that, and for those of you who haven't had a chance to look at the draft yet, I think that was really helpful to see, here's what the group discussed. So, with that in mind, what does the 14th look like for people in April?
Good on my end.
Yes?
Yeah.
Okay.
And I have a webinar listed, and it's not very helpful on my calendar, so I don't know whether it But I can, it's not me speaking, so I'm sure I could do
As long
it.
as you're not presenting, River.
I'm not
that's
presenting.
Okay, so 9 a.m. on the 14th. And then I'd like you to tentatively hold something the last week in April, just as a wrap up.
Yeah, agreed.
And if we don't need it, if we get through everything really quickly, then we can release it. But what does the 28th look like?
It's good on my end.
We've got a Portland tax forum that day.
Those things start at 7 a.m. So no.
They do start at 7 a.m. So we're done. We're supposed to be done by 9. So it's probably fine. I'll just be.
I can't make the 28th. We've got our first business and tax retreat
Oh,
since the pandemic started
congratulations.
up in Victoria.
Nice. Do we want to try to do either the 27th or 29th?
7th works.
27th, I've got a board meeting, so I may be the stumbling block, but go ahead and
And the 29th is better for me because I teach from 10:15 till noon. So
The 20, which is better?
the Friday.
The Friday is better. Okay, so do we want to hold the 29th then?
That's fine.
And we'll just
Looks
plan on
good.
how, and so, we can release that if we don't need it. But I think that will get us through. We should be done by then. Yay.
Great. So
Okay.
you'll all receive notifications on that from either Debbie or I soon.
Yeah, and Debbie, if you wouldn't mind sending those out today, if it's not too much trouble. One of the problems that I personally have been having is that without things on my calendar, things get scheduled on top of them. So I'm actually going to have to leave today's meeting a little bit early, by about probably 20 to noon. So it would be very helpful if we could get it on the calendar soon.
Debbie, I'll make sure you have all those email addresses during this meeting. I'll send those over to you.
Fantastic. Great job. Okay, so with that in mind, Cody.
I'm gonna get. Would it be helpful if I put your document up on the screen? I'm happy to.
Sure, whatever is helpful to people, I'm happy to roll with.
Does anyone have a preference in there, Valerie?
I have no preference. I can open it up on my computer too. So
Would anyone how about this? Would anyone like it on the screen? I'm happy to do it. All right, then let's not have it on the screen.
All right. The first one that I mentioned here is it's not entirely a orphan part because we did talk about ORS 63.001. I just thought we should just double check with the Secretary of State if they're cool with us deleting this definition of office that's in the ORS that's not in ROLCA. A lot of these provisions of ORS that are not in ROLCA relate to the Secretary of State. And so I just thought, okay, well, since we're going to be checking with the Secretary of State a lot today, I thought it'd be good to check in on this one as well.
So I think that most everywhere that talks about our office actually mentions Secretary of State. So I don't know that it needs to be, I don't think that we need to include it.
Sounds great. That's done. Next one is 63.002. This is sort of another definition section, but it talks about other parts of the ORS and how they apply to the LLC Act. It strikes me as something we would want to keep. But I thought I'd run it by the group, and I even, legislative council will put it where they want, but I've made a suggestion where I think it might make sense to have it be.
And it may be too, Cody, that some of these, we send along to legislative council to say, we think this might be useful in your cross-referencing. Can we, where do you want to put it, or do you think it's important to include it?
Right. Okay, I'll move on. It sounds like everyone's fine with that.
I just want to clarify to make sure I'm getting everything in my notes. So this is 63.002. We want to have a note to legislative council for them to consider it.
Well, yeah, to consider whether to keep it, you know, we certainly, I don't think are advocating for its elimination.
Right.
It seems to me like it may well, I mean, I haven't gone through the entire ORS to find out where all there's references to persons, partners, directors. I'm sure that would be a lengthy project. And it strikes me that we want to err on the side of it keeping this, because who knows what kinds of unforeseen problems or foreseeable problems we'd be causing by deleting this.
Cody,
but,
on that, in the definitions section, the term person does include limited liability company.
Yeah, it's somewhat redundant, actually. 63,
Yeah.
but legislative council can work through that, is my
Yeah,
guess.
I mean, I think that's
right. Well, I think they're focused on chapters other than 63. Like when you see the word person outside of 63, then they're also wanting it to include LLCs, because in 63001, the definition of person is only applicable to chapter 63.
That's a good point.
Yeah, so I think we just flag this one for legislative council, and then they can incorporate it where it's most appropriate.
Rock and roll. The next one is 63.024. And actually, as I was going over this morning, it's not exactly redundant of 56.110. The key difference being that these certificates of the Secretary of State under 56.110 are prima facie evidence, whereas under this chapter 63.024, they are conclusive evidence that these things are on file. So this does add something extra. Rather than calling it redundant, I think we should decide whether we want to keep this conclusiveness or whether we want it only to be prima facie evidence. And if we want to keep it, then I mean, to me, it makes more sense to just add it to 56.110 rather than having it be in the LLC Act. But I guess that's something that the Office of Legislative Counsel and Secretary of State can work out.
What
Yeah.
is chapter 56 specifically?
That's talking about the Secretary of State's powers.
Oh,
just
okay.
in general.
Just to tease out a distinction here, I'm just reading it on the page here. 63, or the first section says, it's conclusive evidence that the document is on file. And the other one says it's prima facie evidence of the facts stated in it.
Yeah.
So those seem to me to be a little different. I mean, it's the facts stated in the documents themselves as well.
Yeah. Yeah. So sounds like we want to keep it. And so we just leave it to OLC to put it where they want it.
Yeah, we can definitely, we can give them that information. Yeah, sure.
Okay.
So can I jump in for just a sec? I think deferring to Legislative Council's office is fantastic, and it's important to do that. I'm not sure who the drafter is going to be on this one, but I'm assuming it's going to be Sean.
Yes, Sean.
And in that case, it's really important for him to be able to attend a couple of your meetings and or make sure you explain what you're doing, because otherwise he'll assume and he's really intrigued by this area and he has some of his own ideas. And so it's really important to either explain your thinking and or make sure you have conversations with him to explain your thinking, because otherwise he can kind of go different directions.
Right. So we've invited Sean to all the meetings and he attended one early on.
He's busy, and I appreciate that, Valerie. I know you guys have been working with him. I just want to reiterate that.
Yeah. And I think I don't know if you've had a chance to look at the notes that Sandy's put together on the draft. I mean, I think it does go through and say that these are the things we discussed. Here's why we ended up where we did. But, you know, I think the plan is that some of us are still going to be having conversations with Legislative Council as the draft moves forward.
And Sean, didn't he used to work at the tax court? So he is pretty, I guess, familiar with these things, I would think. I believe he used to be the attorney, one of the administrative attorneys at the tax court.
Sean Brennan?
I just am mentioning it just because
Yeah,
this
no,
is a
I
huge,
appreciate that.
a huge draft you're doing, and it's awesome, and you guys are doing great work. I just
Yeah,
remind
no,
folks to
I
keep me.
appreciate the caution, Susan. You know, I think some of these issues and so, you know, if they're truly substantive issues, then I think we'll probably have to have a more involved discussion with Sean about them. But you know, I think that some of these where we just want to keep it in concept, I think we can just tell her to put it somewhere.
Right. Well, it sounds like we can make a recommendation where we think it makes sense, and then OLC can, you know, at least that they know what we're thinking. 63.031 strikes me as truly redundant of 56.022, but let me know if anyone disagrees or thinks we should otherwise keep 63.031.
Jamie, would your office feel less empowered if we got rid of this section?
Because it's in 56, I mean, we still have the same power. So I would say it's fine. Don't take away my power, but
we want to preserve your power, but I think it's pretty funny.
Okay, then moving on, we have 63.032. And so this is something I think that we should be having and, you know, put it where OLC deems fit. I've got a recommendation. We could call it section 122. And then I just have a note about there's a couple of references in this ORS 63.032 to other parts of 63. And I just noted for convenience, the ROLCA sections where those concepts are now embodied.
Yeah, and I thought that this was a good a good catch and a good recommendation, Cody. So thank you very much for doing this. You know, this is essentially enforcement power of Secretary of State to make sure that people are doing the things that they're supposed to be doing. So I think we do need to keep it in here. Again, I don't care where it goes, but I do think we need to keep it in the act.
It strikes me as the kind of thing that with the hub and spoke model, this also goes to that conclusive presumption of things being on file, that those are the kinds of things that you know, if and when we get around to doing all the spokes in the hub, those are things I would think we would move to the hub, because I assume that they are things we will want to have be true for all types of entities. But for now, since we don't have those things, it seems to make sense to leave them in 63 or move them to 56, whichever, you know, the Secretary of State and the OLC want.
I think one of the things that we have, it doesn't apply to all of the entity types. This is something that is fairly new to give us this type of authority to do the interrogatory investigations. And so it was basically for limited liability companies and corporations. And so I think that might be the difference of why it's only in certain chapters and not in 56.
Okay. Okay, that makes sense. 63.074. It's I thought this one was not so quick and easy to say, oh yeah, this is redundant with something else, or oh yeah, we should just keep this and put it in the LLC Act somewhere. So I broke it up, and you'll see that there's a certain level of indentation where I've got the three parts of this ORS, and then an additional layer of indentation is my commentary. And the only reason why some parts of the ORS there are underlined is just to separate out the first sentence of each of those subparagraphs, just for ease of visualizing. So under subparagraph 1 here, where it starts except as otherwise provided, LLC can conduct any lawful business, etc. That concept, I think, is already captured in the first sentence of or is already captured by 108B of ROLCA. And 108B provides that a limited liability company may have any lawful purpose regardless of whether for profit. That seemed to me to be redundant of what the ORS says. But if anyone thinks that the ORS adds additional context, wrinkle, limitation, authorization, what have you, then maybe we should keep that concept in from the ORS. So that first sentence, I would recommend striking.
So one point to highlight here, 108B that Cody just read contemplates that you could form an LLC for a nonprofit purpose or to run a nonprofit LLC. And the language that he's highlighted here in subsection 1 of 63.074 seems to contemplate only a for-profit or business purpose. And so I don't know if there's been discussion about that or if anyone cares about that.
I think it's good to extend it to nonprofit businesses. There certainly have been quite a few nonprofit LLCs that are very prominent, formed by rich people in lieu of forming a foundation. So I think we should keep it unless there's a reason not to. But I agree with you, Mohsen. The ORS does seem to contemplate only for-profit businesses.
Yeah, the commentary to the ROLCA notes that some LLC statutes continue to require a business purpose. This act follows the current trend and takes a more expansive approach, allowing charitable activities. And, I'm fine either way. If there are reasons to prevent charitable LLCs, then, I don't mean to shake rock the boat on that.
Yeah, to be clear, I prefer the flexibility of the ROLCA language. I just don't know enough about Oregon law and why there might be reasons why this could be problematic to allow a nonprofit LLC. But if no one here has a reason why we shouldn't allow this, then we should just use the ROLCA language.
I actually prefer the language that permits the nonprofit LLCs, just because it's an area that IRS is looking into right now and has issued guidance on multi-member LLCs for nonprofit entities. So I think it would be better. And frankly, I know of a couple of nonprofits that have subsidiary LLCs. So I think we need to keep that language in there. That would be my vote on that.
I'm sorry, keep which language in?
The language allowing, I had to step aside for a minute there. The language permitting nonprofit LLCs.
Right. Well, that's okay. Yeah, that's we're not. Yeah, that's in ROLCA. So
right.
That's something that's a new change in Oregon law that our adoption of ROLCA would be creating. And
right. And I think that's a good thing.
Yeah. So are we all in agreement that this first sentence of 63.074 should be dropped?
Yeah, I would agree with that. And I think just historically, this is deadwood. I think it was done in the original act when the first LLC Act was drawn from partnership, limited partnership, and corporation statutes. It was an amalgamation of what existed at that point in time. I think it's really deadwood at this point.
Yeah, and I think our understanding of nonprofit limited liability companies and where they fit in the pantheon of entities has really evolved, especially over the last 10 years. So
agreed.
So I would just ask, I don't know much about nonprofit entities. I know we do have a separate chapter for them for corporations. Is there any, is this all we need? Is a little half of a sentence that says you can use an LLC for a nonprofit, or are there other concepts that would need to be adapted?
I think that's all we need for now. I think if and when a group revisits the Nonprofit Act, there may be additional things that they may want to do here. But for our purposes, I think this is all we need to do.
Is there some, I'm curious if we should get the blessing of the charitable activities section of DOJ, or, somebody who might, I don't know whether they would be fine with this, or whether they would say, no, that'll mess up our whole scheme, or what have you like that. So I just, maybe we should run it by them so we don't get buzzsawed at the legislature.
The reality is you could form a nonprofit LLC in other jurisdictions already. So I don't think us allowing it to do it under Oregon law is going to make a
Yeah, and it's
substantial
not-
change.
Charitable activities is mostly the regulatory function, you know, so things like private annulment and those sorts of things is what they focus on. So I think it's not a bad idea to loop them in and just say, you know, we're doing this, and I'm happy to reach out, but I don't foresee there being any issues there.
Okay.
I'll make a note to myself.
Okay. Okay. So then the second sentence, that's the part that's not underlined up there. A person may not organize a LLC for any illegal purpose or with a fraudulent intent. That was adopted in 2017. So I think we've got to keep it. And I suggest we add it as new 201E, since it deals with the purposes of the organizers. I put a not in there, but it shouldn't be there. Not the LLC itself. And section 201 is what talks about who can organize LLC and what limitations, et cetera, there are on that.
Yep.
How you do it.
Sounds good.
When we start talking about, just to be clear, Cody, we should add this to our chapter 201, the ROLCA?
Yeah, so I would add as section 201E, I would add this sentence from 63.074.
I'm make sure I'm looking at the same thing. Which sentence? I'm looking at the document because I just want to add it for our notes.
Yeah, it's the sentence that is not underlined, and it says a person may not organize a limited liability company under this chapter for any illegal purpose or with an intent to fraudulently conceal any business activity from another person or government agency.
Got it. I have it right here. All right, so I will add that to our notes for 201.
Great. All right. 1 second, let me make my own note on that. There. And then we've got, so now we're on 63.074.2, where you'll see down there, I've got underlined subject to laws of the state, blah, blah, blah. So this whole subsection 2, it dates back to 1993, which initially barred professionals like dentists and, you know, et cetera, from organizing LLCs. 2 years later, that decision was reversed, and this subsection has basically looked the same ever since. The first sentence, the one that's underlined, again, it seems to be redundant of 108B, which says LLCs can have any lawful purpose. Nothing in ORS chapter 58 on professional corporations says professionals can't organize LLCs. I'm not sure if there's some other statute that bans that, or if there's, you know, a professional board or standard of conduct or something. So yeah, I'm not sure how necessary or useful or additive this underlined sentence is. I thought I'd bring it to the collective wisdom of this group to see if anyone thinks that this is useful or important.
I think it would be confusing to keep it, frankly. So I would advise, as you recommend, Cody, getting rid of it.
Yeah, and I hate to assume Michael knows all the history of all these things, but you've got the experience and you seem to know what is a vestige of a cobbled together 1993 statute compared to what was thoughtful in a sense.
I'm tending to agree. It's also deadwood at this point. I'm just looking at the rest of that section. And it was a cobbled together section once they allowed LLCs, professionals to be LLCs, but integrated the cross liability issues with the rest of the entity statutes. So I think it's deadwood.
Okay. I thought maybe if we drop it, it might be helpful to add an official comment to section 108, just saying that we don't intend any change in the law by dropping this. But if people think that comment isn't even necessary, we don't have to do that.
I think it doesn't hurt to have a comment. And if Ledge Council doesn't think it's necessary, they can take it out.
Well, they don't control our comments. We'll control our comments. They can control the statutory text.
I think it's fine.
Yeah, I think the comment's fine. I mean, I think this is an area that has evolved since 1993. So.
Okay, so the second sentence here is I have a different thought on. So it says, notwithstanding any other law, LLC members who are also professionals are personally liable as members of the LLC to the same extent as shareholders of a professional corporation, as provided in those ORS chapter 58. And so that sentence concerns a concept addressed in section 304, which we've already talked about, liability of members and managers, but it adds a new ground for personal liability for members that's not included in section 304, which is that these professionals are liable as professionals, as members in the same way as the shareholders of a professional corporation are. And when you look at ORS chapter 58, you'll see in 185 is describing this liability that they have. And as I read it, I'm not an expert on 58, 185, but it strikes me that the key provisions are that the owners are personally liable for misconduct of persons under their direct supervision and control, and they're also jointly liable with their professional co-owners in Oregon for misconduct committed in the rendition of professional services in Oregon. And there's a cap on that joint and several liability, which is currently $300,000 a year. So it strikes me as this is a substantive provision that, and it's been around for a long time, since 1995, I believe.
I wonder though, Cody, if this is one of those vestigial provisions where it's in here because people didn't really understand what LLCs were and what LLCs members' responsibilities and rights were. I think our understanding of these concepts has evolved since then.
I disagree. I think this is essentially saying that you can use a LLC in a manner similar to how you would use a professional corporation. However, the liability consequences would be the same as they would be in a professional corporation. So I think this is actually something that needs to be included if we're going to allow LLCs to be used in a manner analogous to a professional corporation.
That's how I understood it, is not so much as a vestige of a cobbled together act, but as rather as part of the bargain, that allowed professional professionals to organize as LLCs instead of PCs. Is okay, we're going to give you this ability to choose the LLC form, but we're going to hold you to the same liability standard as if you did a PC. That's what my assumption was. I haven't looked at the legislation.
Cody, that's just, I do remember that, and it was part of the compromise because prior to this, people that were professionals were trying to jump into LLCs to have, full liability protection that you couldn't get if you formed as a PC. And so the legislature basically neutralized the LLC as an entity where you could do that. So it was part of ultimately the compromise. And at the same time, they added those liability limits for derivative liability, how much you could be held liable for, the malpractice of your partners.
I'm so glad you're on this committee, Michael. It's really helpful.
So your assumption is correct. That's part of the compromise that occurred.
Okay, so given the compromise occurred in 95, is it still relevant? Okay.
Sorry about the one question I have. It says, okay, who are also professionals is defined in 58. Oh, never mind. I was in the wrong statute. 58. Is that actually defined?
Yeah,
in 58?
58015 defines it.
Okay.
And give me a second, I will.
Yep, it is there. I was at a 58-185. Yeah. Sorry.
Okay,
We
so
can keep going.
what I'm hearing from the group then is that we think that this is a policy decision that should be incorporated into the new draft.
Yeah, I think the legislature, if they want to change it, they could decide to do that, but I think we should keep it. One thing that I was thinking, and then I thought maybe it's not a good idea, is that professionals generally have ethical standards that would, the bar, whatnot, would prevent this sort of activity, or at least sanction this sort of activity. But I think it's definitely valid to include it in the state law as something that maybe is more regularly enforceable than ethics standards.
Uh-huh. Okay, so
I
And
don't know that changes the charge to this group though, right? So, I think what I'm hearing from everybody is that we want to incorporate this language into the draft, with a comment that many of these professions are probably already subject to ethical limitations. Does that sound
yeah,
right?
and I was suggesting we incorporated at 304C. It would be a new subsection under 304, which 304 again talks about liability of members and managers. And since this relates to that, and is this sort of a special wrinkle on that, we would add it there.
Yep.
And then finally, this is now 63.0743, which says that a business that's subject to regulation under another statute of the state may not be organized under this chapter if the business is required to be organized only under the other statute. In my view, this sentence is like meaningless surplusage. If there is some other statute saying you can't organize your business as an LLC, then why do you need this statute, which doesn't even say that you can't organize that business as an LLC? It just essentially refers you over to the other statute without actually citing any particular statute that says this.
Cody, without knowing what other statutes might exist, I think to the extent there are other statutes that say you can't organize this type of business as an LLC, I think we need this language, because otherwise we've created an internal conflict in the ORS, because this statute simply says you can form it for any lawful purpose. And I guess what you're saying is, well, it's not a lawful purpose. Look at elsewhere in the ORS. So maybe I agree with you that maybe we don't.
So why don't we just, my suggestion would be that we go with Cody's suggestion that we delete this, but maybe with a comment to legislative council saying, is there a reason for this thing to exist?
Ideally for our carpet layers who presumably are able to form LLCs, it would really be great to have a cross-reference to those other statutes. And I don't know what they are, and I'm not sure that's our job, but just in terms of helping people follow the law, I would think it would be super helpful.
Yes, it would be nice if there was a master list of cross references to all of the provisions.
Is that part of what legislative council does, is find out if there's actually a statute that this subsection 3 is assuming or referring to some potential other statute that actually says what this is assuming a statute might say. Is that part of what LLC does, is to go and say, oh yeah, there is such a statute. It's in the statute governing nonprofits, and it prohibits nonprofits from organizing as LLCs. And given our change, what we're doing with 108, now we've created this conflict like Mohsen just identified. Like, I don't know, I'm just curious, what do we do about that? Does LLC, do they do that work, or is that our job?
My understanding is that LC has much more comprehensive legislative history about a lot of these provisions, just because they sort of accretes around them, right? I also do know that they have better cross-referencing than we do. So, I mean, I think I'm fine punting this to LC to say, hey, is there a reason for this to exist? And then if they push back on that, then we can have a bigger discussion about it.
Okay,
Yeah, I guess I would say, I would recommend getting rid of it. And then
Yeah.
in terms of LC saying, well, if you want to keep it, could you maybe add some cross references so that people know what you're talking about instead of being just sort of this interorum kind of thing? Oh, well, go ahead, but you might be in big trouble because there are these other statutes that we don't know what they are, but they're around.
yeah, yeah. The only one I can think of would be potentially the nonprofits. And I didn't look there to see whether there's a rule that they can only be organized under this chapter. That would be the one that would potentially create a problem.
Wondering if it's like banks and insurance companies or,
Mm.
other regulated institutions like that. I don't know if they can only be corporations. I'm thinking there's probably some regulated type of industries that their governing statutes require a certain entity structure. I'm just guessing there. I don't really think this adds a lot to the LLC Act. I mean, I would be inclined to agree with some of you. We recommend it be deleted, but pitch it to Legislative Council to tell us why it should stay in.
Okay. Thanks, everyone. So the next one is 63.170. This says, so this one's complicated. I've got a lot of notes here on this one, as you can see. This says that LLC is liable for loss or injury caused to a person or for a penalty incurred as a result of a wrongful act or omission or other actionable conduct of a member or manager acting in the ordinary course of the business of the LLC or with authority of the LLC. And I really want to emphasize here, it's either if you're acting in the ordinary course of business or with authority of the LLC. This was added as part of the legislature's substantial modification of the LLC Act in 1999, which adopted all or most all of the original Uniform LLC Act. And this language has appeared in the Uniform Partnership Act since 1914. And the comment to that act says, for the most part, this parallels the agency law doctrine of respondeat superior. And as you know, our court has interpreted the LLC Act. That's certainly true, I think, as with regard to the authority. When you're doing things under the authority of the LLC, I think it basically does parallel respondeat superior. But there's that separate language about in the ordinary course of business of the LLC. And that's separate and it's additional path to liability. And that is a path to liability that some other states, many other states, I haven't done a head count, but certainly there's other states that don't have that alternate pathway to liability. And this is something that, in many cases, you don't need that because you'll get there under respondeat superior to get that liability, or, the authority language, the common law agency principle will get you the liability. But there are several examples through the case law as well as commentary to RUPA that indicate that there are instances where liability would be had under the ordinary course of business test, but not common law agency principles. So for example, if the conduct at issue is not part of the member or manager's scope of employment or authority, but is part of the LLC's ordinary course of business, then you're going to have liability only under this statutory test. And so a comment to RUPA cites, I think there was actually a case that they're citing in that comment to RUPA, where the partner filled in for a line cook at the restaurant because no one else was available. So it was not part of the ordinary course of business or usual employment authority of the member to be a line cook, but that was part of the LLC's ordinary course of business. And therefore, for this reason, the partner or the LLC was liable for what the partner was cooking. I don't know, maybe they made a bad hamburger. Another example is if the LLC doesn't have the right to control the physical details by which the member or manager is performing their duties, and this person is not an employee, and they commit a tort resulting in physical injury to the plaintiff, there's no liability for the LLC under common law agency principles. But if what this person is doing is in the ordinary course of business of the LLC, then you will have liability under this provision. And then I've cited here some cases from Oregon interpreting, this ordinary course of business language, in particular under RUPA. There's a case from 1986 where a lawyer was held liable for their partner's malpractice under this ordinary course of business. The partner had taken a personal loan from a client and had not advised the client about the loan, which was the malpractice. Even though it was a personal loan, the court held that the other partner was liable here, or I should say, the partnership here, it would be the LLC, was liable for that because this was a client, and advising clients, even if you do it badly, that's in the ordinary course of business in our case, it would be an LLC, but
So,
there was
Cody,
a partnership.
How does a attorney take a loan from a client without the client knowing? Is it taking it from the
No,
from
the client knew about the loan, but the client, the allegation of malpractice was that the client should have gotten advice about,
okay.
There was another case where a husband ran partnership committed conversion by leasing out property that belonged to somebody else. It was, essentially the one tenant left, and I believe they left like a bunch of restaurant equipment behind, but it was still that prior tenant's equipment. And then the husband ran partnership, leased out all that restaurant equipment to the new restaurant business that came in and was the new tenant. The wife had only co-signed the lease, and she was still a partner in the partnership. She was liable under the ordinary course of business test because leasing out the property was in the ordinary course of business of the LLC. So those are a couple of examples here where liability has been held to attach under this ordinary course of business test. And I have that in there because when I first read this, I was asking myself, well, what is added by that ordinary course of business test? And there is something added by it. Now, it's definitely clear that ROLCA has gotten rid of that. That is the kind of statutory apparent authority that ROLCA doesn't like and has dropped in favor of the common law model. And the ROLCA commentary specifically calls out the RUPA 305 as a provision that they have dropped. That's this ordinary course of business test. ROLCA explains that this change will not significantly alter the commercial reality that exists between LLCs and third parties because very few current LLC statutes contain rules for attributing to an LLC the wrongful acts of the LLC's members or managers. And therefore, this change is just acknowledging pre-existing reality. On the other hand, that may be true in other states, but it's not true in Oregon. This is an actual change in Oregon law.
Cody, where's that commentary in ROLCA that you're referencing?
I believe it's in sort of the introductory preface.
Okay.
I didn't cite the page number here, but if you do a word search for the quoted language, it'll come up. I can bring it up here real quick.
Looking for it. My reaction is that this is a good nuance that you've highlighted here, and it would represent somewhat of a policy change with respect to questions of LLC liability, but to incorporate this language from the ORS would be contrary to the general framework that ROLCA has created to just build itself off agency law principles. To create LLC liability for actions taken in the ordinary course of business where there would not be liability under common law agency would be different than what ROLCA contemplates, which is that common law of agency is really what's deciding who acts on behalf of the LLC, who can bind the LLC, and who can create liability for the LLC.
Yeah, And we did, certainly with regard to, contracts, when we were talking about the ROLCA sections about liability of the LLC, with regard to contracts, this is a change also in the contractual situation as well. To me, that's, that change is understandable, because when you're contracting with the LLC, there's a bit of a caveat emptor. You have the opportunity before you enter into this arrangement to make sure that you're entering into an arrangement with somebody who is going to be a good contracting party that you're going to be able to rely on to uphold their end of the bargain or enforce it if they don't. I think in the context of a tort, you don't have that opportunity to suss out common law agency principles. Therefore, some injury has been foisted upon you, and you don't have any control over it. And
you will always have a claim against the tortfeasor. And the question that we're really asking now is, should the LLC be liable for the tortfeasor's tort?
That's right. Yeah.
Did you have a recommendation here, Cody?
Well, my recommendation would be to keep that ordinary course of business language, but I wanted to see what the group thought.
I would go in the other direction, to make the statute coherent internally. The statute relies on common law agency principles to determine who can act on behalf of the LLC, who can bind the LLC in contract and otherwise create liability for the LLC. And so to include this language would deviate from that basic principle that's guiding ROLCA, and make it arguably incoherent, although not. I think one thing I heard you say, and my own interpretation, is the scenarios where you could get liability through the ordinary course of business statutory language that you couldn't otherwise through agency law principles is a relatively unusual circumstance.
They may be. Yes, I imagine that, I don't know what the percent is. I imagine 80% of the time you're going to have liability under common law agency principles. And it may be bigger than 80. It may be 90% of the time, or 95. I don't know what it is, but I definitely agree that in the vast bulk of the circumstances, this isn't going to add an additional avenue to liability.
I would agree with Mohsen on this one, that I think bringing this in would muddy the waters of where we've decided to go in terms of ROLCA, and really doing away with statutory apparent authority. We're not doing away with common law apparent authority in those avenues that you can get to the principle for the acts that create damage by the agent. So I would probably not bring this into ROLCA, because I think we would really be creating a confusing situation as to what the statute really means.
Does anyone feel that we should keep it? I think that by dropping it, I think we ought to, at least in our commentary, add something noting that, this is part of the ROLCA change and we're going along with it.
Yep, agreed.
And maybe give a shout out to the fact that we're not undermining common law apparent authority, respondent superior concepts in any way.
So Michael, you mean we don't intend to?
We don't intend to change those common law principles. It's just the concept of statutory apparent authority. People look to the Secretary of State website to make a determination on authority, those sorts of issues.
Anything else on that, or should we move to the next section?
Just a question of where that commentary should appear. I think it makes sense to be a comment to section 301 of ROLCA. the other possibility would be 304.
What was 304?
304 deals with
Oh, yeah.
a limited liability shield.
Yeah, I know. I think 301 probably makes more sense. Because the commentary that I was talking about from Rolka is on like page 3 and 4. It's like the very beginning where they're talking about here are the big changes we're making. So I will add that. Okay, the next one now.
Can I just ask something? Because I'm sorry, I'm just searching around through Rilke and it does say, so what I hear Michael saying is we're not eliminating or maybe we are eliminating statutory apparent. We are eliminating. Okay, then never mind. I will be quiet. Thank you.
Not eliminating common law concepts.
But we're eliminating statutory apparent authority,
Yes.
just like Rilke does. Okay, thank you.
Yes.
Yeah.
Okay, 63,810.
Now, you all might think because I clerked at the tax court that I know a lot about tax law. That would be a mistake. I don't know much, if anything, about tax law. So 63.810 is something that I'm going to look to you all to, and maybe we need to talk to the Department of Revenue. I don't know, but you tax people, this is your sandbox, so I defer to you.
Hi, Cody. This is Victoria from the Department of Revenue. Are
Hi.
you?
Oh, I'm so glad you're here.
So are you wanting on the spot commentary on
If
this?
you have, if you have any, is this, this is, I mean, I can, in my layperson understanding, figure out in a sense what this means, but I'm assuming that there's all kinds of subtext that you all know about from provisions of the IRS or our own revenue code that are helpful to an understanding of this paragraph. And I just thought I would see what the tax people think and what the Department of Revenue thinks what we should do about this language that is in the ORS, but it's not in Rolka. So,
So
should
Victoria,
we use language and where and how?
is this just saying that if you check the box for federal tax purposes, we're going to treat you the same way in the state?
Just a moment. I'm working on a one screen laptop here from my basement, which has been delightful for the last 2 years. But I can't see the document and
I'll copy and paste the language. I'll copy and paste the language.
Or,
oh, I know I can't. I have your notes up, Cody. I'm saying I can't see you and the notes at the same time. And I had you guys up on screen and now I've lost my place in the document. So give me the statute number again, please.
63.810.
63.810. 63.810. There we go. What do tax people think? Okay.
I think all that is saying is that if you check the box for tax treatment under federal law, that we're going to treat you the same way under state law. So if you're an LLC and you say, oh, I want to be a partnership, we're going to tax you as a partnership. And if you check the box to say, I want to be taxed as a corporation, we're going to tax you as a corporation. That is, I don't know any of these ORS chapters that are being cited here.
Roberta, where I think this is coming from, I think this is a vestigial provision from when people didn't know how LLCs were going to be taxed. If you look at really old operating agreements, you see a lot of language in them about, oh, this is not a corporation. This is, taxed under the partnership rules. So, I think that that's where this is coming from. I think it's vestigial. I don't think we need to keep it, but that's just my perspective on it.
What I'd like to do, for instance, the notes in here, chapter 305 is a lot of it's our governing administration of the tax code. I'd like to take this back, run it by DOJ and either email everyone here at the first opportunity, which would only be a couple days from now, or report back on I think the next meeting is on April 1st, is it not?
Yeah,
Would that be all right?
that's fine. Yeah, I mean,
Okay.
I'd much rather know if DOJ has any concerns about this
Okay.
now rather than, yeah, down the road. But that's
Yep.
what I think, because I think it's not important. You know, and it looks like the legislature's looked at it a couple of times, the last time of which was in, you know, 209, but I think that was probably a statutory update, so, or, you know, reference update.
Mhm.
So, but yeah, let's get DOJ's perspective on this.
All right, thank you very much. I
Thank
will,
you, we appreciate it.
and then report back at the next meeting, or would you like an email in between?
An email in between would be helpful if they can turn it, because it's going to be 3 weeks, and that way we can circulate it to the group.
And
But
Victoria,
Okay. Yep.
and if you just send that to me, I'll get that out to the full group.
All right, Sandy.
Thanks, Victoria.
Awesome. Okay, so 63.955 is talking about the interstate application. And so limited liability company organized and existing under this chapter may conduct its business, carry on its operations, and have and exercise the powers granted by this chapter in any state, territory, district, or possession of the US or in any foreign country. I'm not sure what that adds to the equation, really. 108, you know, talks about how, you know, I guess you can have any lawful purpose, and anyway. So I guess 108 doesn't specifically state this concept. 109 says a limited liability company has the capacity to sue and be sued in its own name and the power to do all things necessary or convenient to carry on its activities and affairs. Doesn't limit it to you can only do things in Oregon. I don't know if this is an important statute or not, but it strikes me as, you know, sort of implicit in at least section 109. But if people think this is important, otherwise there will be a fear that LLCs are only allowed to operate within the state, then we should keep it.
I think it's deadwood at this point. There were some when the LLCs first came in that might have been of that mindset, and I think this was meant to give those folks solace, but it's deadwood now.
So maybe I would think maybe it would be helpful to add a comment to section 109, just saying that, hey, we dropped 63.955, but that's implicit.
Right.
Okay.
Great.
Okay. Next is 63.960. So this says nothing in this chapter is intended to supersede the provisions of 679.020, which says only dentists can own dental practices, and they've got to maintain records, those dentists. And dentists may be a powerful lobby in Salem, or, there may be some, I don't know, assumption about I don't know why this is in here, and maybe Michael knows.
Answer to that one. When did this come in? Interesting.
I'll note that dentists are included as professionals within the definition of 58015, talking about who can do professional corporations. And I'll also note that ORS 58.369 says nothing in this chapter is intended to supersede the provisions of 679.020. So, the dentists are really getting special treatment here throughout the ORS, and that may be important, but it may not at all be important. I don't know.
Jamie or Kevin, do you have any thoughts about this? You still with us?
Yes, sorry. I'm looking at it and I'm not sure. I don't have really anything to say. I feel like we talk about 58, the references to 58 in different places, and that's for the professional, when they list themselves as a professional limited liability company. I would think that should be sufficient and not necessarily just for dentists, but for all professional limited liability companies. So I really don't have anything I don't know that we need this. And I don't know if Kevin's still on, if he has any other idea on that, but I don't really see any reason to keep it.
Hello, everyone. This is Victoria again from Department of Revenue. ORS 58375, which I understand we're not discussing at the moment, is the requirements for professional corporations organized to practice medicine. Oregon is one of those states that requires that only a physician, and I presume, I know dentists are not doctors, but the reason I bring this up is that we have had tax cases, big ones recently, that center on whether or not a physician is the owner of a medical practice in Oregon, for instance, as opposed to a physician management service that is headquartered somewhere else, such as Delaware or Florida. But so I'm not sure that, so I don't know what the impact would have, if any, on what we're doing over there in revenue by removing this requirement that a dentist must be the owner of a practice.
Well, we're not removing that requirement. We are removing the reference in chapter 63 that says we're not superseding anything in the dentistry.
Oh,
tax.
okay.
So, you know, and this is one of those things that, you know, maybe it makes sense, since we're going to be talking to DOJ anyhow, maybe see if they have any concerns about this. You know, my thought is that it's surplusage. What was it, Cody? What was your phrase? Unnecessary surplusage or something like that. I like that phrase. But again, like I don't see a reason to have this in here, because the requirement about ownership still exists in the ORSs.
Okay.
But again, this is why we have this great group of people, is if we have other folks who have concerns about it, we want to know about them. So Victoria, if you're talking to DOJ anyhow, you might ask them, you know, in light of those cases, is this something that is important that we keep?
All right, I will add that in.
Thank you so much.
Yeah, I mean, it would strike me that potentially it would be wise to, you know, talk to the Board of Dentistry and
Yeah.
the Dental Association. Dental Association, I'm sure, would be happy to get rid of this, but the Board of Dentistry may be really married to this statute.
Would that be through the governor's office? How do we even reach out to them? Sandy, do you know how to reach out to the Board of Dentistry?
I could figure out how to.
I'm sure they have a website which advertises a phone number.
Yeah.
Sure,
Okay.
I'll set as a task for myself.
I think that's a great follow-up item.
Okay.
Mention is, I'm trying to think now, maybe we've already talked about it, but maybe I'm just muddled in my thinking. I don't think there's anything in ROLCA that says, hey, you know, I mean, ROLCA is all about all these wonderful things you can do and no limits. How does that interact with the provision of 58, for example, that says only doctors can own medical companies and only dentists can own dental companies of any kind? I just want to make sure we're not creating I would imagine that 58 may be sort of the more specific and therefore controlling statute, but and maybe all we need is a comment to that. But if there's big tax cases riding on the fact that a doctor needs to own the doctor company, whether essentially it's an LLC or a PC, then maybe we don't want to cause trouble.
I think this is something we can keep in mind as we go through our cleanup, which is part of why I wanted to do this discussion before we start the cleanup. But you know, I mean, it's not even that the chapter 58 is more specific. It's that I don't think that ROLCA says anybody can be a member of an LLC, right? And anybody can, you know, share ownership of an LLC with anybody else. I don't think that's in there. At least I don't recall it being in there. So the qualifications of a member are going to be governed by the professional standards.
Well, you mean, but it's not like standards of conduct, but it would be governed by
The statutes.
this 58.
Yeah, the
in
statutes
particular.
specifically govern businesses owned by doctors.
What is it in chapter or section, what, article 2? Where's the one that talks about who can be a member? There's got to be something saying who can be a member.
Well, 401 talks about becoming a member.
Yeah, what's that say?
Yeah, and it doesn't talk about, it talks about the,
Right, I mean, there's no limitation placed on it. I mean, I think ROLCA effectively lets anyone become a member. I see Mosa nodding.
Definition of member means, I'm looking at 102. A member means a person, and then person is defined, of course, very broadly. But then it goes on to say how you become a member, but there's essentially no limitation on who can be a member as long as they're a person, as that term is defined.
But is it appropriate to have a limitation in the LLC statute? Should the, should it be in the, as you say, in the doctor statute or the dentist statute about?
well, and I think that that's what this section 63960 is talking about, right? Is it's sort of a belt and suspenders approach. And I guess the question for this group is, do we need a belt and suspenders? And if we're going to have a belt and suspenders, should it be more broadly based to say, if you are a regulated industry and your industry says that you have restrictions on membership, then, those control.
Right, I mean, maybe, I would think it would be prudent at minimum to add a comment to, let's say, section 401 or somewhere else saying that our deletion of 63.960 is, not intended to say that we're now trying to override chapter 58, that 58 will still be the more specific and controlling statute as regards, dentists or doctors or what have you.
I guess I would go with that approach and punt it to legislative council to see if they see otherwise. I note that there's not a counterpart to this in ORS 60, but there is in the PC statute. So, I think it's already inconsistent amongst the entity statutes.
Yeah.
Yeah, so let's follow up with DOJ. Let's follow up with the Board of Dentistry and see if anybody has any strong concerns about deleting this. But my suggestion would be that we delete this to be consistent with ROLCA. But if someone has strong concerns, then we can certainly revisit this. Okay.
Great.
Okay.
Okay, 63.990, I think we need to add it to Article 11.
Okay.
This is sort of the Oregon choice to have all these criminal statutes at the end of every ORS chapter rather than in the criminal code.
Right.
And so we need it here, I guess.
Yep, that's fine.
And the last one, this is 63.992. This was just added in 2017. It's the stuff about how liability for operating a shell entity. And I think we need to add it, and LLC can do where they deem fit, but I would suggest we do it as a new section 306, since Article 3 is talking a lot about liability of members and managers and so forth.
Yep.
Cody, where's shell entity defined?
It is defined, give me 1 second. It's defined in the ORS right now as 63.001, and when we went over that the other meeting, we had decided to add that definition of shell entity to ROLCA section 10, I forget if it's 102 or whatever the definition section in ROLCA is.
Thank you. Yeah, it's 102.
And it means the entity that has the characteristics described in 63.661 1AC1. Very exciting, which means it's one that's used or organized for an illegal purpose, used or organized to defraud or deceive a person or a government agency, or was used or organized to fraudulently conceal any business activity from another person or a government agency. That is a shell entity.
Good. Yep, I think that's a good add. Great. Thank you so much, Cody. This is a lot of work. I really appreciate it.
Thank you.
Yeah,
Thanks,
you
Cody.
bet. You bet.
Okay, I'd like to propose that we take a break until 10:30.
Can I just interject for one moment? Sandy, you have up the document that you shared with all of us, correct?
Yes.
Okay, I'm looking at that same document on web browser, and it doesn't show these changes. So I'm gonna play around with my web browser unless there's something. I mean, I think I'm looking at the same document on my web browser, just doesn't show all these changes. So let me see if I can figure out what's going on my web browser.
Yeah,
Maybe I don't have the updated document.
This reflects the changes that I made last night.
Yeah, you may want to change it to the, so if you look at the top of the screen, if you want to be reviewing it as the reviewing, rather than, that's how I'm seeing it, but it maybe just how the document's being viewed.
Okay, so Jeff was going to do this, but he's sick, unfortunately. So we'll send good thoughts to him about feeling better. So I think generally speaking, this is going to go pretty fast because, like I said, I think we discussed a lot of things the first round through that we just need to make sure are incorporated here. So with respect to section 101, which is just the short title. Sandy, could you go up, please? Yeah, I think, yeah, so what we did is we adopted it, and I think we're calling it chapter, right? The final bill should cite as the Oregon Limited Liability Act. So any concerns or questions about 101?
The word company is missing. Oregon Limited Liability Company
Yes.
Act.
Sandy, could you add that, please?
Yeah,
The commentary.
good call.
And acknowledging that it's always hard to type in front of an audience. So, okay, 102. So I think that we decided to keep the name articles throughout ROLCA. So I agree with that first edit. And then as far as other edits to go, you know, my notes reflect what we've got right here. So section 15, which is on page 10, we were going to add adopt it as is, but add a comment that person, as we understand it, includes foreign and domestic persons or entities. And then I had added in that their principal office language, there were some changes in 63001 sub 29 for transparency. Is that in anybody else's notes?
Physical location, I think, is what I wrote down.
Physical location. Yeah. So yeah, so Sandy, maybe add in parens physical location there.
Just make sure I'm on the right one. That's the number. That's a 15 or that's a 16?
16.
Okay. Hold on, I'm typing.
Mm-hmm.
There it is.
And then
So what did we decide about the commercial mail receiving agency and stuff? Or so we're going to incorporate all of that, A and B of 29?
yes, I think so, because wasn't that the
That's right.
Yeah.
I think that's correct because you need that definition to backstop some of the other additions that we made later on.
Right, and I think we decided that was added as part of the transparency stuff. You know, their rewrite for transparency purposes. No, Sandy, it's not 29. Don't. Yeah.
So I think up there at 16, maybe it's physical,
16.
add both A and B, I guess.
Okay.
Because,
Yeah,
because
Sandy, it's a reference to 63.001 sub 29 A and B.
Yeah, and it's little a, little b.
Got it.
Matters.
It'll help me when I go back into it. A, little b.
Yeah.
And can I ask a quick question? I'm assuming that, so this is sort of just like notes, but when we go to the legislature, for me at least, it would be helpful to have a document that is a clean version of ROLCA, and
Right.
then it has red lines on it showing the changes from ROLCA that we have decided to
Right,
make.
which is what are you, Sandy? I can't.
I'm sorry, I apologize.
Stop. I can't track what you're doing. So
Sorry.
if you look farther down in this document, that's actually exactly what's happening. It's just that section 102 is such a long section.
Thank you.
that
That's
it made sense because and we didn't really make that many changes to it. So I just wanted to highlight in here. But if the group thinks it would be useful, then we could put in, and maybe we should put in the text of 102 and then add these changes, which is essentially what the other sections do.
Valerie, I'll do that after this meeting. As you said, it was just an exceptionally long section. That's the only reason.
No, I understand.
We would do that just so we can get closer to the ultimate deliverable.
Yep.
Right. Yeah. And so, yeah, Sandy, if you could do that with these edits, I think that's reasonable.
Yep.
Okay. And then 19, which is at the bottom of page 10 through page 11, I had a note that we were going to include the definition here from a registered agent. Is that consistent with everyone else's?
From 63-111.
Yep.
Sorry, what?
Valerie, would that be in the definition section or someplace else?
Well, so we have registered agent here, right?
Right.
And then 63-111 sub 2 defines what a registered agent is, or who may serve as a registered agent.
We may also have been thinking about sub 1 of .111, which talks also about physical location and mailing companies, mail
But I
forwarding.
thought all of that stuff is in section 115 of ROLCA.
Right, but I think if we're talking about definitions about, let's see, let me go to 115.
Well, I don't think 63.111.2 is a definition of a registered agent. I think it's a substantive requirement on who may and may not be a registered agent. It's not saying, you know, who it is. It's saying who can meet that definition.
Okay, yeah, and I got a note in 115 saying that we need to add in that in sub B of 115. So I think as long as we're putting it in somewhere, I think that's fine. And then 21, I had a note about us wanting to include, sorry, someone else say something? 21, I had a note about us wanting to include a comment just referring to the Electronic Signatures Act, that it's out there. And so an electronic signature is going to be governed by that. Those were all of my notes on 102.
So I have two comments.
Okay.
One is, would this be the place where we would say we're adding the definition of shell company? Make that comment here.
Yeah, that's a great idea.
And then second, we were still arguing over the definition of distribution.
Arguing is a strong word.
And also, if we're talking about incorporating the language from, I mean, I think someone just said this, that should go to ROLCA 115 and not be here in 102, the registered agent part.
Right, and so we can delete that comment on 19.
Or move it.
Right, well,
No, I don't. I think we can just delete what is about to be deleted by Sandy right now. I think we can just delete it here, and we
That's
will
fine.
talk about registered agents when we get to section 115.
Okay, so go ahead and delete that, Sandy. Yeah. And then the shell company definition, since we were just talking about this, isn't that at 63001?
31. That's right.
31.
001 sub 31.
Yeah.
We also, I thought, had decided to add the definition of anniversary from ORS.
Okay.
At least
I had
that's what
that
my
note too.
notes say.
I had that note too, and the word anniversary doesn't appear in ROLCA. So I was trying to figure out which piece of ORS we're retaining that has that.
That's 63001 sub 1.
Well, that's the
My-
definition, right?
Yeah, my notes indicate we didn't make a decision on that one, but I have bad notes.
So, I mean, I think James's point is well taken, though. If we're not using it in the act,
Right.
then we don't need to define it.
So the only place I see it, I just did a word search in chapter 63.
Yeah.
And the only place I see it is in .787 relating to annual reports. Which I'm sure ROLCA covers in a different way.
Right.
Right, I agree.
Jamie, do you feel strongly that we need to keep the word anniversary in the definitions?
I do not feel strongly.
Okay, so let's go ahead and not do that. Okay, anything else on 102?
Yes, the definition of distribution, there was a discussion of whether we would include only the first part of it and not the inclusions and exclusions. And I'm relatively agnostic about that. Some states have adopted the whole definition, which is in ROLCA. Other states have not. They've adopted only the first sentence. And part of the reason is the previous version of ROLCA, from what I could see, didn't have the second part, the inclusions and exclusions. So it depended a lot of times whether or not when the state adopted that definition. Although having said that, excuse me, the state of Washington adopted only the first part of that definition. They certainly adopted it after the 2013 version of ROLCA.
Well, and this may be a question for our bankruptcy attorney here, because if you look at the comment, the definition, which is at 4 on page 8, the comment with respect to the B exclusion language, says that it limits the reach of charging orders, charging order remedy under 503 and 405's clawback provision.
And last time we were talking, that part was not, I think, controversial. It was this first part, the inclusions, because it included redemptions.
So it's the only part you were talking about maybe deleting is 4AI.
Well, my preference would be to include the whole thing, but what states have done, they've either included just the very first sentence for all intents and purposes, and they haven't added either I or 2I, if I'm looking at that.
I think I like ROLCA as is.
I think the issue with the second one is dealing with like severance agreements or any other payments that will be made to somebody, not to buy them out as a redemption, but separate from that. And that could be captured within the definition of distribution under that Roman numeral 2.
Well, the commentary says that the point of it is to make it clear that that would not be deemed a distribution and thus not subject to a clawback or a charging order.
Because of B?
Well, I'm just reading the commentary.
Yeah. No. I'm just trying to see where it says that in the language, though.
I think, Cliff, you were talking about a Roman numeral 2, right?
Correct. Yep.
Yeah, and David, I think you're talking about B.
Right. Exactly.
I don't think reasonable compensation would cover the scenario I was covering.
Because you're talking about a severance payment to go away as opposed to payment for,
yeah.
My preference to the extent it matters is to keep ROLCA as is.
That would be my preference as well.
And Cliff, your reservation is with Roman numeral 2 because you think that shouldn't be captured in this definition of distribution.
Correct. Exactly. I don't
Why?
see, well, I don't see a reason for it. If you're going to make a redemption, yes. If you're going to make a distribution in terms of tax distributions, operating distributions, liquidating distributions, specifically, to all members, I think that's one thing. If you're isolating one member, and the payment is not through a redemption, I don't know that should be able to be clawed back.
I look at the corporate side, that could be clawed back, because I think under the Corporate Act, a distribution would include a redemption.
No, and Dave, I'm not arguing redemption. I think that's covered in 1. I think 1 should stay. And I think Roman numeral 1 is consistent with most statutes.
So what would we call it then if we're not going to call it a distribution? I mean, how would you characterize that payment in exchange for relinquishment of a right?
It's funny, the commentary doesn't even discuss that.
Right.
Particular.
As I see it, I hear your severance payment scenario, Cliff, but what I see this trying to get at is a redemption disguised in another way, in that someone might retain their membership interest, but are really foregoing rights that were previously associated with that membership interest. And so, right, it's almost like a redemption, even if they might otherwise retain their membership interest. Right, they're relinquishing
It's
the
a
right.
diminution in their rights, right?
Exactly. And so that is akin to a redemption, even if you might, in some capacity, retain an equity interest in the entity.
So Mohsen, would you characterize that as a partial redemption? Not really?
I mean, sure, we could use the language partial. I'm kind of curious what the statutory drafters were getting at here. As I read it, it seems like an anti-circumvention provision to allow for something to be characterized as a distribution, even though, or a redemption, even though the member who received the redemption payment otherwise retained a nominal equity interest.
So
That's
I
what
think
it strikes me as well, because as a member, you have 2 things. You have your economic right, your transferable interest, which is what I is getting at, redemption. And then you have your management rights, which is what II is getting at. And I think it's basically, oh, you're going to try and get cute and say you're paying this person as a member for their management rights, not for their economic rights. And you're going to say that's not a distribution, but you're giving them the money because they're a member, not because they're an employee or occupying some position other than as a member. That's to me what it's about.
So I agree with Cody's, and they talk about the bifurcation of a membership interest between economic rights, which are the transferable interests, and governance and information rights in the opening paragraph of the commentary.
So is this something we should add commentary to explain why we're adopting it in full, since the Rilke commentary doesn't really talk about it? And I think Mohsen's explanation and Cody's clarification are really helpful.
That would work for me, but
Yeah, I mean, we can add a comment about, I think, both 1 and 2 here, right? So Sandy, could you please put add comment about 4, so it's sub 4 distribution, why we're including A1, A little I and A2 little I?
Well, what is the commentary? I mean, I would just let the statutory language speak for itself. I think it's telling us what a distribution includes, what is captured by the definition of distribution. And I think that speaks for itself. Us trying to explain why we included it might muddy the statutory text.
Yeah, I personally don't feel it requires a commentary myself, but if people want to have a comment, You know, I mean, I thought our comments are more about explaining why we do things differently from ROLCA when we do things differently from ROLCA, or to explain why something we didn't carry over from ORS is not meant to be a substantive change. I don't really think that we need to be commenting on why ROLCA is written the way it is if we're just adopting it verbatim.
Yeah, that's my perspective on this provision as well.
Roberta, do you feel strongly that we need a comment?
I don't feel strongly about it, but I just note that since we had confusion over it, there might be confusion over it when it goes to Ledge Council as well. And I don't know if there's anything similar in
Okay,
ORS.
so
I mean, because people said, oh yeah, redemptions. Yeah, that's all the state statutes have redemptions. But what's this other thing?
Right. So maybe comment is the wrong word here. Maybe note to legislative council might be more appropriate.
Or maybe it's just the fact that we've talked about it. This is legislative history. Yeah. If anyone's curious, they can come and listen to they can watch our video of us with our little heads on the screen right now.
Sounds like a plan. Okay.
Can I go back real quick? I think shell company is shell entity.
It is, yes.
Yep.
So not to beat a dead horse, and I think I maybe at this point, but what's gained by Roman numeral 2 there? It's not captured in 1, because if they're still being paid for even a partial interest, that would be captured under 1.
Well, it may not be it may not be a full interest. It may be, you know, one of the bundle of sticks associated with the bundle of sticks, right?
Right.
But I think that's covered under 1 still.
Well, but let's say, because transferable interest, right? 1, you know, I only covers your transferable interest, which is defined as your right to distributions. You know,
It's your economic right. Yeah.
Your economic right. And II, 2, it makes no reference to economic rights at all. It's talking about giving up your management right and your right to information. So if I am an LLC and I form you know, let's say I write it all up and I say, I'm going to give you $1 million and you lose all your management rights and rights to information, but you keep all of your economic rights as a member. I'm giving you this $1 million. II makes it clear that this is a distribution, because you're being paid to give up management rights, which are rights a member has.
Yeah.
And you're not having to give up any of your economic rights in doing this deal. So it's not covered by I.
Yeah. So for example, if you fire the manager and he or she agrees to step down to just continuing to be a member, that payment would be covered under this, right?
Well, and this isn't talking about a non-manager member. So it would only be a member manager in this context. It's got to be someone who's a member.
Okay.
Is
But
that
still, isn't that, so if we're saying you can no longer be a manager, you've done these bad things, but we just settle with the payment.
No.
That'd be
If
considered a
if you read the section, it says any right to participate as a member.
Right.
So in your example there, they would be losing the right to participate as a manager, but that's not specifically tied to their membership rights.
So does this mean the member who gets, I should phrase it differently. Does this mean that the person who gets this payment relinquishes their right to vote? Or is it broader than that or narrower than that?
Yeah, or maybe they don't give up any right to manage the company. Maybe all they're giving up is their right to access records. I mean, it's kind of interesting to me that this is contemplating that you can give up your right to records and give up your right to management. But if you do that, you may just say, I don't have right to access records anymore. I give that up and you give me money. That's going to be called a distribution because it's in your capacity as a member. It's not in your capacity as an employee or as a pure manager It's because you're a member, you're giving
Yeah,
up.
let me give you the following scenario. A member understands that the LLC's on the brink of a potentially what's the word? A lawsuit that's going to make the LLC insolvent. And so the member devises the following scheme. In return for consideration of the LLC's assets, the LLC will I'll give up my right to access records on the weekends, which I previously had as a member, right? If we don't include this language, that would not be considered a distribution. Even though I think you would agree, Cliff, that's a distribution.
Well, I don't know that omitting II necessarily means it wouldn't be a distribution. I think this whole AI and II is just a clarification so that there's no doubt.
Right. I agree with you, Cody. I just think I makes explicit that scenario is a distribution.
Yeah.
It just feels like it's opening it up too much.
Well, but this isn't.
I'm in the minority here, so I'm absolutely willing to drop it and move on in the sake of time, but.
Well, and Cliff, like, I think you had given an example earlier that maybe a manager, let's assume they were a member manager, they had done something wrong, and then there was going to be some kind of a payment to, I think, resolve the issue.
Mm-hmm.
I don't think that's what this is getting at. This isn't about the LLC giving up a claim against a manager for wrongdoing in exchange for a payment, or I guess it would be the, here it would have to be the manager, I guess, complaining, the member manager saying that they've maybe been oppressed or there was an attempted squeeze out, and the LLC is going to pay them money to settle their claim. That's not what this is getting at, because then the member is being paid not just because they're a member, but they're being paid to resolve a claim, as opposed to giving up their management rights or their rights to information.
And it wouldn't necessarily have to raise to the level of a claim, right? It could just be that the member has had an argument with the other members and just says, I don't care. I just don't care. I'm not gonna do anything but pay me to not do anything.
Yeah, I mean, potentially there's, people could try to circumvent this by trumping up some fake claim, to call it a settlement of a claim, and therefore it's not a distribution. I assume the courts are duly capable of looking past that and seeing what the reality of the transaction is. I just think that I don't see a reason to depart from Rolka on this.
I agree with that.
So any more discussion, or I think Cliff, if you have thoughts on this that occur to you after the meeting, because that happens to me sometimes, and you want to revisit this next time, we can.
Totally. Let's move. Totally fine moving forward, Valerie. I think I'm the only one arguing my side, so let's move on.
So section 103.
Well, I'd like to jump to, before we move to that, I have a note that under the definition of person, that we had also wanted to add a comment that this can include professional corporations and tribal governments. I don't know that that's necessary, but that's what we had, I think, decided before.
I have a totally illegible handwritten note next to that, so it's possible.
So Sandy, this would go under 15 above, where you already have, say, add comment, the person includes foreign and domestic persons entities. It would just be an additional comment that it also, there's a reference in this definition to business corporations. And we had said that was going to include professional corporations. And then also the reference here to, government stuff was going to include tribal government.
There is this catch-all at the end, or any other legal or commercial entity that I think would capture those things, Cody, but there's no.
Yeah, no, I'm not advocating that we need this comment, but I think we had decided earlier, and at least my understanding of what we were doing now was primarily making sure we capture what we had previously decided, and then potentially reopening things to discussion, but. Anyway.
Yeah, and so Sandy, I think instead of making that part of the definition, I think it's, yes, okay, so we do have it as part of a comment.
Yeah.
Okay, I think that's fine.
So OR 63.00, 15 has or the definition of entity has a fairly much more comprehensive definition of entity than ROLCA does, but I agree with what we're doing here.
Okay.
Just commenting on it, which includes recognized Native American or American Indian tribal government, among other things. So
anything else on 102?
I do.
Push you
I
all
have
along.
I have a note that under the definition of transfer, under E, so transfer, this is section 23 or subpart 23. It includes an encumbrance, including a mortgage or security interest. And I thought the Secretary of State was looking into this because our 63.249 sub 7 says the pledge is not an assignment. And we were wondering if that mattered. I don't know if that matters or not, or if, I mean, I'm fine with ROLCA as is, but I had thought the Secretary of State was maybe looking into this.
I don't remember that I was looking into it, but I'm not sure if I feel like it matters.
I'm fine to just have ROLCA as is, but I just wanted to, at least I have my notes. I wouldn't want to drop something if there was something to be done.
Tara, do you have any thoughts about this too? Are you still with us?
Okay, my only other comment was then, since we're about to move on to section 103 of ROLCA, is just that we should note in here that we have adopted 63.002. This is something we talked about this morning, as that needs to come in here in between section 102 and 103.
Yep.
Cody, to the one point actually on section 23 transfer and encumbrance, I just want to make sure I generally think of the term encumbrance being very broadly defined and to include any restriction on a transfer of a unit, which would usually be within any operating agreement would include restriction transfers. Is there any, and I haven't looked through the act, but is that problematic anywhere? Given that there's essentially encumbrances placed on LLC interest out of the gate for most entities.
Well, I guess I didn't look up what I was just reading my notes right now. I hadn't reviewed like what the thinking behind the note was, but I had assumed that encumbrance doesn't include just some contractual, like in the LLC operating agreement, for example, limitation on your ability to transfer to other people. I thought it was more like, like mortgage or security interest, something that's probably recorded, or, I mean, maybe it doesn't have to be recorded, but if you are, giving up your right, you're pledging it in some way, you're giving someone a security interest in it.
So if encumbrance is not specifically defined in ROLCA, which it doesn't appear to be, is this something that we go with state law to determine what the definition of encumbrance is? So that seems like maybe what you're getting at, Cliff, if you think of a transfer restriction on transfer of membership interest, is that an encumbrance?
Yeah, I mean,
to me that's more like debt.
Black dictionary, any restrictions on transfer. Straight from law school still.
I'm impressed.
Yay.
Don't look at it. But I don't know if it's problematic anywhere. I just wanted to note that.
Yeah, I think that's reasonable. Hey, Tara, do you have any thoughts about this? Since you deal with this whole issue a lot more than most of us.
So I'm trying to get to the definition of transfer here. So tell me exactly what the issue is. What's the concern?
Well, a transfer includes an encumbrance, and encumbrances, if at least using the Black's definition of encumbrance, would include any restriction on transfer. So anytime we are entering into a operating agreement, we're essentially imposing an encumbrance, so which would be considered a transfer. I have not looked at the act to determine whether including that an encumbrance as a transfer is problematic anywhere. So to the extent, I just think somebody may want to look at the use of transfer throughout the act and see if, again, to see if it's problematic.
Well, and I
Yeah,
think,
no,
you know,
I'm happy to take a look at that. It's hard for me stepping into Teresa's shoes so
absolutely.
late in the game, but I'm happy to take a look at that and get back to everyone on that.
That would be fantastic. Thank you.
Sure.
Tara. And I think that, you know, isn't it Article 5 when we're talking about rights of creditors, maybe where some of this comes in?
Sure.
If it's,
Absolutely.
if it's helpful, the conversation I remember is in 502, it says that a transfer in whole or in part of a transferable interest is permissible. So I think the idea under ROLCA is all kinds of things are by default permissible. And I think you get to the same place under 63. That talks about under 249, it talks about a membership interest being assignable unless the articles or operating agreement apply, say otherwise. And then in sub 7, it says the pledge, granting of a security interest lien or other encumbrance in the membership interest is not an assignment. So it's not even addressed, which I think means it would be permissible.
yeah, and I think
It's
that,
helpful.
I
James,
think,
thanks.
yeah, my understanding is that Cliff was focused more on the concern, does that word encumbrance include sort of any limitation on your ability to make a transfer that would be contained like in an operating agreement? I personally, I mean, I think it wouldn't. I think you'd read it in peri materia with transfer includes assignment, conveyance, sale, lease, gift, you know, things like that. I think it would just mean, you know, security interests. I mean, I don't even know why they describe a mortgage as something other than a security interest. It is a security interest, so.
Yeah, I'll take a look at that. And it seems like, Cliff, your concern is that maybe encumbrance should be defined.
Yeah, or even so it's not so broad. Correct. I mean, it sounds like we're all of the opinion that it should just be a mortgage or security interest or something of that sort instead of the
Agreed.
definition.
Again, in 249 under current law, it does use the word encumbrance without definition, just for what that's worth.
Thank you. Yeah.
Okay.
And this may not be problematic at all.
Anything else on 102? Going once, going twice. All right, section 103. So 103, I have a lot of handwritten notes, but I don't have us making any changes to this section.
I agree, and I only have us wanting to add a comment. I thought we had decided to add a comment that 63034 sub 4, 5, and 6
Yes, I
are
have
all
that.
circumstances where knowledge or notice occurs under section 103A and B.
Yep. Do we have that
Sorry,
in here?
it's down. If you
Yeah,
look,
it's down under overall.
it's right here. It's in overall. And what I'll do is I'll move that up so it's more clear with statute.
Well, I think this is fine, actually, the way you've done it, Sandy.
Okay.
You know, because what we have is and this is what I was talking about when we were talking about giving what we're going to give legislative counsel. So Sandy, if you could scroll up to the top of 103.
Mhm.
So you see that we have the language here, and then if you go farther down, then you have the comment.
Mhm.
And there's no changes here, but if we were going to make changes, we would reflect those in the text of the document.
Yeah.
So I think that this is what I anticipate us giving to legislative counsel. But yeah, that comment is already noted down below. But as far as, you know, here's what we discussed, here's what the comment is. I think that captures it. Okay, 104. Yeah, and here we do need to add in the text. Oh, no, hold on. I'm looking at the wrong section. 104. Yeah, so the text is here. I don't have any changes or comments here.
Okay.
104. Does anybody have any changes or comments that we need to incorporate in 104? Okay, excellent. Look at us going fast through these things. 105. 105, I do have, hold on.
And I'll admit, my notes in 105 were scattered because we talked about it over several meetings. So there's definitely stuff that may be missing.
Yeah, and I went in and incorporated what I have as far as edits go. I think that we changed all of the acts to chapters globally throughout this. It's going to be 63A. And then I have the most notes with respect to sub C 5, 6, 7, and 8. I think we took out sub C. Where are we?
Is this wait?
No, go up. Yeah, there.
Got it. I see it.
Yeah, so sub C, I had us taking out duty of care language. And then the words manifestly, and then making those changes to sub 7. Does anybody else have other edits?
I'm sorry, can you just, so it may not, in 5, you had us taking out or the duty of care.
Yeah.
I had that note too, Valerie, when I look back.
Does anybody else remember these edits differently? This is why it's so good to have the group to go through this, because, you know, people are engaged at different amounts, I think, as we're going through this.
My note says that we had discussed eliminating duty of care, but we had ultimately decided to leave roll cut alone on that.
Yeah, which is not what I've got. Does anybody else? How do other people feel about this?
I missed a number of meetings, and I thought, however, that this was a section that we had reserved to discuss after we've discussed everything else. And so I was not under the impression that we had made any decisions, final decisions with respect to 105.
Does anyone have any notes on why we would want to take out the duty of care?
I think because it's not, let's see, 63, 155. I have a note about 63, 155. Let me scroll to that. Yeah, I think because it reflected, let's see, not unreasonably reduce.
Well, oops, I just lost it. I'm also working with one screen and things disappear. So
63, 155.
63, 155, 3 does talk about duty of care.
Finish.
Yeah,
So,
sure, go ahead.
Yeah, so 63, 155 at 3 and then at 10. So what we're talking about here is an operating agreement may not, right? And then if you go to 63, 155, 10, it does say that it may not unreasonably reduce the duty of care. So maybe I don't know. I mean, maybe we should discuss it here. What do people?
Well, I mean, I think that if you include this duty of care language in C5, it just begs the question, what do we say about the duty of care in D? Which is addressed in a minimum in D3C. If you eliminate the language or the duty of care from C5, then what you are doing is you are allowing people to completely eliminate entirely the duty of care.
And I think, so I wasn't here for any of this, and so I have no idea what was said and what was decided, but the rationale would appear to me that under corporate law, you can already fully exculpate directors for breaches of the fiduciary duty of care. And it seems to be, it would be consistent with what's already permitted under corporate law to allow the same here. This goes a little bit farther in the following respect, which is this is not talking about simply eliminating liability for a breach of care. It's talking about eliminating the substantive duty itself, which means that not only could you not be liable, there couldn't be an injunction against you for a breach of the fiduciary duty of care, but it largely gets you to the same place you already are under corporate law.
Right. So, look, ROLCA, if you adopted ROLCA just as it is, all of it, then what it allows you to do with the duty of care is you can, so long as it's not manifestly unreasonable, you can alter the duty of care, but may not authorize conduct involving bad faith, willful or intentional misconduct or knowing violation of law. But again, there's that's sort of cabining your ability to muck with the duty of care. But if you delete the language, the duty of care from C5, then there's no rails, no cabining in your ability to completely eliminate the duty of care. So I think what we had decided, my notes reflect that we had decided to leave the language, the duty of care in C5. What we did not agree about, and it's still an open question, is what do we do about the language of D in terms of what limits are there on your ability to vary the duty of care? And I also agree with most, and I think as we go through 105 C and D, they are the political footballs that we had decided to punt to the end. And I don't know whether you want to go through political footballs now as part of our running through section by section, or whether we want to go through section by section with the non-political football issues and leave footballs for the end, the true end.
I would rather do it as we go through, unless other people feel strongly the other way around. I'd like to be able to say that we're done with a section when we're done with a section.
That's fine.
So I'll plant a flag. I personally do not think it's a great idea to get rid of, or to allow people to get rid of the duty of care entirely. I know that is what you can do in Delaware. And I frankly, even as a corporate lawyer, it strikes me as sort of offensive. I don't think it should be totally allowed. So I think restoring this language in 5 here and then having a conversation on D about what you can do makes sense to me.
Agree with James.
Okay, so we get rid of that deletion then. Does anybody feel strongly that we need to keep that deletion?
No, I think we should get rid of it.
Okay.
Just trying to remember how to get rid of an underscore on this thing. Not under a cross out.
Can't you just undo or reject the change?
Go up to review. No, Sandy, go up to review on the top bar.
It's not a track change. It's done with formatting.
No, it's a track change because I turned the track changes on. So it's a track change. So go ahead and reject that.
There's no line on the left side.
You know what? This is one that I had actually changed
Oh, did you?
prior. Yeah, I'll fix it.
So why don't you just type in or the duty of care and we'll call it good.
I'll delete it. Yeah.
Yeah, there we go. Okay. Okay, good. Excellent. Okay, so that's 5. 6. Manifestly unreasonable.
This is one that I wasn't here when this was discussed, but it seems highly problematic to me to have this struck.
Okay.
My notes show that we had agreed to keep section 6 here as it is and not delete the word manifestly. I know we debated the issue, and this is what I think we had decided on. That Oregon law uses the phrase unconscionable, whereas ROLCA uses the phrase manifestly unreasonable, and then it defines it in E, I mean. It defines what manifestly unreasonable means.
There's a comment on that on page 36. about the not manifestly unreasonable concept became part of uniform business entity statutes coming from the UCC.
Right, right. Well, my notes indicate that we had agreed to leave manifestly unreasonable language in subsection 6 here. And that it was a political football how we define manifestly unreasonable. That is what my notes show.
Okay, does anybody feel strongly that we should delete or not delete manifestly?
I feel strongly that we should not delete manifestly.
Okay.
The manifestly should appear in the text.
Does anybody feel strongly that we should delete it? Okay, go ahead and undelete it then, Sandy. Okay, 7. I have that we added in whole or in part at the beginning. And then we added breach of duty of loyalty language.
I don't understand what this accomplishes. Subsection 5 already tells us that you cannot alter or eliminate the duty of loyalty except as otherwise provided in subsection D. And so we need to look to subsection D to see in what ways you can alter or otherwise eliminate loyalty. This is essentially seeming to impose an additional restriction beyond what's in 5 and D.
No, I think this goes to what you said earlier, Mohsen. 5 talks about altering or eliminating the substantive duty itself, and 7 talks about liability for breach of the duty.
I worry that what 7 invites is for a court to say, well, you can say what you want in your contract, but there's still a common law fiduciary duty that cannot be changed pursuant to this subsection 7. And so I'm going to apply this common law duty that exists beyond what you say in your contract, in your LLC agreement.
What? I'm sorry, I didn't understand that.
Yeah, I don't understand that either, Mohsen, sorry.
What I worry is this invites a court to say what subsection 7 says is that you can, that there's a common law duty, fiduciary duty of loyalty, and you cannot in your operating agreement pursuant to subsection 7 alter the liability consequences that arise from that common law duty of loyalty. And so it invites a court to apply a common law duty of loyalty, even though the parties may have attempted to alter the substantive duty itself in the terms of the LLC agreement. That essentially allows a court to sidestep whatever the parties may have said lawfully in the LLC agreement about the content of the fiduciary duty of loyalty, and apply a common law version of the fiduciary duty of loyalty to find liability on the part of anyone who might owe that duty.
Oh,
I don't see that, but that's.
yeah, I personally don't see that either. I mean, D is going to talk about what you can do with the substantive duty of loyalty. And again, that's a political football. But assuming that whatever we do under D, I mean, even in ROLCA, even that's, this pretty broad language in ROLCA that allows you to alter or eliminate aspects of the duty of loyalty, if not manifestly unreasonable, it still leaves room for there to be some level of a duty of loyalty. And then the question here under 7 is, can you relieve or exonerate a person for liability that violates the duty of loyalty, whatever substance that duty has?
I guess
the issue here, I think, is not about, is there some free floating duty of loyalty existing outside of ROLCA? I think the question is, I think we all agree that there's going to be the duty of loyalty as defined in ROLCA and as potentially additionally limited by the operating agreement. The question is whether you can exonerate a person from liability for breaching the duty of loyalty, whatever substance it has. And ROLCA allows you to completely exonerate a person from their breaches of duty of loyalty completely. And I thought as a group had decided to not allow that, to exonerate you from liability for that breach.
Is that the concern here, that without this additional language, there's a concern that an LLC agreement under the model language would allow for complete exoneration of a breach of loyalty?
Yeah, I think that, and I haven't re-looked at C6's commentary, But I think that's exactly what ROLCA would allow you to do.
So the commentary is on page 29. And it talks about the term bad faith having multiple meanings, and the context determines what meaning applies. In the context of the duty of loyalty, bad faith includes conduct motivated by ill will or other intent purposely to harm another person. I'm not sure what that means, but they do refer to the duty of loyalty. So I think that adding this language, I read it the same way Cody does, and I think adding this language would not, I mean, it might be belt and suspenders, but I think it would be consistent with the intent of ROLCA.
I agree.
Okay, I'm happy to move on, and then maybe there'll be a need to revisit this once we look at what D says.
Don't threaten us with a good time. Okay, so moving on.
Sorry, on 7, because I know that we had previously agreed and, put aside what we may want to change now, but the in whole in the part language and the breach of duty of loyalty, we had agreed. I thought that it remained still a question that was open, whether to add recklessness in addition to breach of duty of loyalty to section 7.
I don't have any notes about recklessness, but this was 2 years ago, so it's possible.
Cody, if it's all helpful, I had a note about reckless, but it was down in sub D, not up here in 7. If that helps at all. But it was a cryptic note.
Uh-huh.
I remember seeing reckless somewhere, and thank you. That's probably where it was.
So for example, ORS 63-155 says that it talks about your duty of care, and it references that it's limited to refraining from, this is in the context of winding up. It's limited to refraining from engaging in grossly negligent or reckless conduct, intentional misconduct, or a knowing violation of law. And
Cody, I'm sorry, what subsection is that in 63?
63-155 sub 3. And ROLCA talks about in section 409C, ROLCA says the duty of care of a member or member managed limited liability company and the conduct or winding up of the company's activities is the complementary position or provision, is to refrain from engaging in grossly negligent or reckless conduct, willful or intentional misconduct, knowing violation of law. So it talks about how part of the ROLCA duty of care in the wind-up context, at least, is you cannot be reckless. ROLCA's
I have a note
105.
about recklessness on D, on where is it? On D3C. I think that's what and so to the extent that we're discussing this, I think it makes sense to compare C3 or C7 with D3C.
Right. And again, that stuff in D is going to be talking about how do we define the duty itself,
right?
And what freedom do people have to redefine the duty? And then this section 7 is saying, however that duty is defined or indeed eliminated, what is the deal with liability for a breach of that duty, however defined?
For what it's worth, under Delaware law, at least, gross negligence and recklessness are deemed to be roughly the same thing. And so if we added recklessness to this list of things that cannot be exonerated against, again, this would make our LLC statute in conflict with much of corporate law, which allows exoneration or exculpation for any kind of gross negligence or recklessness.
Right. Well, I mean, they have to have different meanings. Rolka defines them. Rolka describes them as different concepts. And I'll throw out also that, you know, I don't think we ought to be just following Delaware and doing everything Delaware does. Delaware, I think, is a terrible model.
No, what is does Rolka define recklessness and gross negligence differently?
I'm sorry, I heard what Mosen said, but not what Cliff said.
A lot of attorneys disagree with you on that one, Cody.
No, I understand. I understand. That said, Rolka does not define, I don't think, recklessness or gross negligence.
And my point is that I at least in Delaware, and I don't know, I can't speak to other jurisdictions, they use those terms to mean roughly the same thing. And so to the extent that the statute here is referencing both concepts, it might just be because different courts might use different words to mean the same thing.
So we made a decision early on that we were going to go with the Rolka language unless there was a substantive reason not to. Is there a substantive reason to insert the word reckless in here that reflects a policy decision maybe that legislature's already made?
Well, I don't think Oregon law currently allows you to relieve or exonerate a person for liability from recklessness. Is that wrong?
I think that's correct.
So, I mean, I think that's a significant change. And as we get into D, you know, I know there's a lot of political footballs we're getting into. And I think that we, you know, in general, I want to keep as much substance to these duties as possible and minimize the ability to exonerate people from their breaches of these duties.
Cody wants us to form more Delaware LLCs.
If that's what people decide to do, I think that's the better way to go. I mean, I think you look at
63-155.
I think 63-160 is the one I'm looking at.
Well, can I finish, please, Mosen?
Please go ahead.
So 63-155 addresses at sub 3 addresses a member's duty of care to each other. And, you know, that's limited to engaging in grossly negligent or reckless conduct. And then if we're talking about the indemnification provision, there is at 160, there is not a inclusion of reckless language. So that's where we are currently in Oregon. Is there a substantive reason to change that?
Is indemnification different from, I mean, I think indemnification is different from
63-160 speaks to both indemnification and exculpation. It deals with both limiting liability and indemnifying against. So it says it may indemnify or may eliminate or limit liability of member, manager, employee. Stated differently, I think 63-160 already allows for exculpation of gross negligence or recklessness.
Right. And so in that case, with that framework, what does that mean for sub 7? So we're talking about the operating agreement may not. And if we're talking about adding in it may not relieve someone from reckless behavior, then I think that's a change in where we are currently. So I think I'm going to side with Mosen on this one, because in the interest of not making a change to Rolka and reflecting current Oregon law, I think that's where we end up.
Right. So if I'm understanding this right, just as a matter of what Oregon law currently allows you to do, am I correctly reading 63-160 that it allows you to eliminate liability for breach of the duty of care entirely?
That's right, and that's consistent with corporate law.
So are we talking about not adding reckless, or are we talking about
not adding reckless to sub 7?
Okay, so we are still going to keep the liability for conduct involving a breach of the duty of liability that we've decided to keep.
Right. I think so.
Okay, all right. So it's just a discussion about reckless, in which case I agree. We don't need to add it.
Okay, yeah, and since it appears that the reckless is only a part of the duty of care in ROLCA and in current Oregon law, and current Oregon law allows you to eliminate entirely liability for breach of the duty of, not being reckless. I think that ROLCA as written, where you can eliminate liability for recklessness, is consistent with current Oregon law. It's not a change at all. Is that correct?
I think that's correct.
Well, then let's not add recklessness in.
Okay.
So at the risk of upsetting Valerie by going up in the document rather than down,
No!
we just talked about 63.160 allowing us to eliminate entirely the duty of care. Is that why we had in 5 the concept of eliminating the duty of care? I mean, I think if we're gonna say you can't alter the duty of care, now we are saying we're making a change in Oregon law to
No. So subsection 5 deals with altering or eliminating the substantive duty itself. Subsection 7 deals with exculpating for liability of a breach. So you could, under subsection 7, eliminate liability for a breach of the fiduciary duty of care, so that if someone breaches care, they're not going to be monetarily liable. But it may still be the case that that breach is of a type that can be enjoined, right? So there could be equitable relief against that kind of breach that doesn't involve monetary liability.
is that the distinction that that's the practical difference between what we're talking about here is equitable relief?
I
Well,
believe so.
And that's also consistent with Oregon law, because in 63-155, there is, you're allowed to reduce the duty of care, but you can't do so unreasonably. Just like under ROLCA, you can alter or eliminate the duty of care so long as it's not manifestly unreasonable as provided in D. And so having 5 in ROLCA include the words the duty of care is consistent with current Oregon law, where you can alter that duty, but you can't eliminate it entirely. There's restrictions on how you can muck with the duty of care. And then in 7, though, just like under 63-160, you can completely eliminate liability for breach of that duty of care, but you can't completely eliminate the duty itself.
I withdraw my question, and Valerie, I owe you a lunch.
So I actually have to leave. So do we want to call it now, or does someone else want to take care of driving the ship forward?
Let's call it.
Call it.
All right, so we will start. We'll start next time after spring break with section 8, having concluded our discussion on section 7 of 105. And what we'll do is we'll start with the follow-up items that we talked about today. So if you agreed to take a follow-up item, and I think that's principally Victoria and Tara is what I've got on the follow-up items. If we could start with that, and then we'll move forward on 8, because I think we're going to have some additional discussion on the rest of this section.
And during the meeting, Debbie was at work doing the scheduling, so you should all have an invite to all 3 of the meetings we scheduled. If you do not, let me know.
You guys are amazing. I really appreciate you, and thank you. So I will see you in 3 weeks.
Thank you.
Bye.
Thanks, Valerie.
I will continue to add to this document as I keep incorporating my notes after section 4. So feel free to add your notes to this document as I add them. So you'll see that updated. It'll all be, I'll try to get as far as I can by the 23rd, but at least through, I'm going to try to actually get the whole way because I've committed to that. So you'll see that by the end of the day on the 23rd.
But if you have anything prior to section 8 of this section that you need to have additional notes on, don't add them, because we're good. If we need to talk about anything, then we can talk about it later. Okay. Yes. Thank you. Have a great spring break if I don't talk to you before then.
Bye.
Bye.
Bye, everyone.